Undocumented immigrants in the United States are entitled to many of the same constitutional rights as citizens. Yet less than half of all undocumented immigrants go to immigration proceedings without any legal representation, often resulting in deportation to a home country they desperately try to escape. Refugees and asylees being those seeking asylum or have already been granted it, must satisfy the exact same legal requirements to receive an immigration status. But asylees can have their protective status revoked, whereas refugees cannot. As we can see, refugees, asylees, and undocumented immigrants are all entitled to various legal rights in U.S. law. Yet when those rights are put into practice, mounting disparities emerge. This is precisely the phenomenon that we explored in our research.
This project was a year-long process that involved collaborative research roles. With Zach being a pre-law student, he looked at the laws that govern undocumented immigrants, asylees, and refugees, and held extensive interviews with immigration attorneys to see how these laws look in practice and what disparities emerge between the communities when those laws are put into practice. For my part, as an asylum applicant myself that has had to navigate the disparities of the immigration system in America, I looked at the community resources that attempt to bridge the inequities that the immigration laws in practice create by interviewing nonprofit immigration aid organizations and members of the undocumented immigrant, asylee, and refugee community in the Cincinnati metropolitan area. In simpler terms, Zach looked at the disparities that immigration laws create, and I looked at the community resources such as nonprofit organizations, churches, and legal aid societies that try to alleviate the inequities.
So why does a project like this matter? Well, to begin with, immigration law is unique in that it is created by the U.S. Congress, but overseen and enforced by the president and the executive branch. Unlike most other fields of law, the judicial branch, that is, the courts, have very little power in immigration law. Whatever is not explicitly stated in law is left to the discretion of executive branch agencies and even individual officers such as ICE officers. Current research on this topic offers a lot of data regarding what rights and potential benefits undocumented immigrants, asylees, and refugees have in the United States. There's also extensive research on the community resources they interact with. What current research falls short in providing, however, is an analytical synthesis between these two topics to examine how immigration law looks in practice and how community resources respond. Overall, our findings show refugees to be at a strong advantage above asylees and undocumented immigrants. Although the refugee community certainly endures heavy hardships outside of the United States, and even during the immigration process, once they are granted refugee status here in the United States, they are very well protected in the immigrant community. Certain pieces of legislation, such as the Refugee Act of 1980, explicitly gives refugees rights and protections such as resettlement assistance to find employment and housing, family and community prioritization, and even financial assistance. Asylees are not given the same explicit protection in law, which therefore leaves many of their rights and potential benefits dictated by the discretion of immigration agencies and officers. Pablo's findings indicate that because of this, pro bono legal organizations and legal aid networks have to interact with asylees on a much larger scale than with refugees.
Undocumented immigrants stand as being the most disadvantaged immigrant community both in their legal rights and their accessibility to community resources. Little to no congressional legislation gives rights to undocumented immigrants, and even their so-called due process right was created by court decisions and gives undocumented immigrants about a fraction of due process that it gives citizens. In regard to community resources on a broader sense, I found that there are major disparities of funding to legal aid organizations between large, medium, and small cities. The federal government gives priority to larger cities, thus community resources in small and medium cities like Cincinnati must prioritize cases that are the most likely to win. What this means is that most of the time undocumented immigrants and asylum seekers that cannot afford an attorney will be turned away from pro bono legal aid organizations, leaving most asylum seekers and undocumented immigrants to go to immigration court without any legal representation at all.
Our final part of the research involved discussing with interviewees about the hopes they have for the future in regard to this topic. The overwhelming majority of interviewees stated that they wanted to see a more immigrant-friendly rhetoric in the executive branch and in the nation as a whole. Many immigration attorneys also expressed their strong desire to see immigration law be removed from the executive branch and into the judiciary branch, so that way all communities are entitled to the same constitutional rights that any criminal defendant is entitled to. That includes full due process, right to an attorney, and equal protection, and more. Just this change alone would eradicate many of the inequalities that we focused on in our research.
The inequalities that exist within immigration law are incredibly complex and will undoubtedly take time to eradicate. However, something as simple as supporting academic and legal research on this topic could help transform for the better the rights, integration, and livelihoods of the immigrant community.